Welcome to our Rotherham Sendias video about what to do if you are worried your child's EHC plan is not being delivered. Before going into detail about what to do if an EHC plan isn't being delivered, it's important to understand what an EHC plan is. An EHC plan is a legal document which describes your child's or young person's special educational needs, which will be in Section B, the support they need to meet those needs, which will be in Section F, and it also outlines the outcomes they would like to achieve in Section E and the school or setting they would like to attend, which will be in Section I of the plan. The plan will also have yours and your child's views, wishes and feelings, which will be in Section A of the EHC plan. If your child has health or social care needs related to their SEND, then the EHC plan will also outline these needs too, in Section C for health and Section D for social care. And the provision to meet those health and social care needs will be in G for health and H for social care. If a personal budget has been agreed to meet any of your child's needs, these will be outlined in Section J of the EHC plan. So if it's in the EHC plan, is it enforceable? Some sections of the EHC plan are there to add information and context, and so are not legally enforceable. For example, Section A, which are yours and your child's views, wishes and aspirations. Section E, which describe the aspirational outcomes for your child, are also not legally enforceable. However, there are some sections of the EHC plan which must lawfully be delivered. Who is responsible for the delivery of the plan depends on which section of the plan the provision is in. The main sections that would want to be enforceable would be Sections F, G, H, and Section I of the EHC plan. Let's start with Section F. So Section F sets out all the special educational provision a child or young person needs to meet the special educational needs outlined in Section B of their EHC plan. The local authority has a legal duty to ensure all of Section F is delivered. This legal duty can be found in the Children and Families Act in Section 42. Although in practice you will see that it's the school or setting that carry out the SEND provision within Section F, the duty to make sure this happens actually sits with the local authority. The local authority has the responsibility to ensure the setting has the correct funding allocation, training and equipment if needed to deliver Section F. So now we'll consider some actions to take if Section F of the EHC plan is not being delivered. Step 1. Although it's the local authority's duty to ensure this takes place, we'd first advise that you talk to your child's school or setting. It's always helpful to arrange a time that you can discuss the issue with a senior member of the school. So this could be the SENCO, the head of year, or the head teacher, for example. It may be helpful to take a copy of the EHC plan with you for this discussion, so you can make reference to Section F, outlining what the EHC plan states must be provided. Ask the school for clarity on the provision that's in place and gain an understanding of why any provision may be missing. Ask if the missing provision could be reinstated without delay to ensure the EHC plan is fully delivered. So if Step 1 hasn't resolved the situation, move on to Step 2. Inform the local authority about the missing provision. You could do this either informally first by discussing the situation with the EHC case coordinator, asking them to contact the school and resolve the matter if possible. You can find their details on the EHC hub. Or you can make use of the local authority's formal complaints process, which you can find on the local authority's website here. So here's some practical tips if you put your complaint in writing via the complaints process. Ensure your letter of complaint includes the following: the date of your complaint, your child's name and date of birth, the fact that it is a formal complaint about the special educational provision in Section F of the EHC plan not being delivered. It may also be helpful to include the date when the final EHC plan was issued. Clarity on the points of your complaint. It might be useful to do this by using bullet points to keep each complaint point clear and to the point and specific. Any actions that you have tried to address this in a more informal way. It may be useful to include who you've spoken to about this matter and any dates. it might be helpful to include an indication of your desired outcome and your expectations around the time you expect to hear back. We also suggest you add your preferred contact method and details, and we'd suggest this is either an email address or your actual address so a response is in writing. So if you put your complaint in writing, here's an example of how to structure the body of your complaint using bullet points. So here you'll see complaint 1, missing provision in section F of my child's EHC plan under communication and interaction. Under this section is the provision which states weekly half-hour speech and language therapy sessions provided on a 1-to-1 ratio by a trained speech and language therapist. And then it states that this provision has not been provided since the EHC plan was finalised 2 months ago, that the parent has made contact with both the school and speech language therapist over the past 2 months to try to resolve the issue, but have not had any confirmation of when this provision will be in place. You'll then see a section that says evidence provided to support this complaint, and this parent is attaching the final EHC plan, which highlights the provision in section F, the attached speech and language therapy report, which details the provision in the first place, and the attached emails that the parent has sent to both the school and the speech and language therapy service in an attempt to try to resolve it. There's then some desired outcomes, and you'll see the first one is that the parent would like confirmation that the speech and language therapy provision will be in place without delay, and if this is not possible by the NHS provider, to please consider making use of an alternative provider. And you'll see here that the parent has then linked some possible alternatives. But there's also a desired outcome too, which the parent would like an explanation as to why the provision was not implemented at the time it was agreed and specified in the EHC plan, and an apology for the delay of the implementation. The parent would then go on to complaint 2, where they would list the next section of the EHC plan in section F that isn't being delivered. Of course, it would be hoped that step 1 and step 2 would resolve the situation and that all then section F of the EHC plan is delivered. However, if this is not the case, the next steps would be to either consider the local government or social care ombudsman complaint or a judicial review. And I'm going to go into a bit more detail about both next. So first focusing on the LGSCO, so the local government and social care ombudsman. This is independent of the local authority, and they can investigate complaints around maladministration leading to injustice. Maladministration means that the process which should have been followed were carried out poorly or not at all. Although there are multiple issues that could come under this type of complaint, one of them is where the help in section F of an EHC plan is not being provided and the child or young person is being deprived of the special educational provision that they need. This body can recommend a range of remedies, including compensation, asking the local authority to make a decision again, or suggesting a change of policy. A person making a complaint to the local government ombudsman would need to show there was maladministration and that it led to an injustice of some kind taking place. The local government ombudsman won't consider a complaint if there is fault but no injustice. This body would need to consider whether there has been maladministration and whether the local authority has acted reasonably within the law, its own policies, and the good practice standards of the local administration. In order to submit a complaint to the local government and social care ombudsman, you would first have to have gone through the local authority's own complaints process. If this has not taken place, they can refuse to accept the complaint. The Local Government and Social Care Ombudsman Special Educational Needs Fact Sheet suggests 12 weeks is an appropriate amount of time for the local authority to deal with a complaint before you consider complaining to the Local Government Social Care Ombudsman. The LGSCO aims to consider all complaints within 28 calendar days. After the initial assessment, they will decide whether or not to do a full investigation of the complaint. They aim to complete all investigations within 26 weeks. However, more complex cases can take longer. Following an investigation, they will issue a decision where they can make recommendations to local authorities. These recommendations are not actually binding on the local authority, but the LA shouldn't ignore them. If you want to consider making a complaint to the local government social care ombudsman, you'll find a link to do that here. So now we'll take a look at judicial review. Judicial review is the process of asking a court to look at the decision the local authority made, and it asks them to decide whether it was made in a lawful, fair, or reasonable way. The court doesn't consider if it agrees with the local authority's decision, but it takes a look at the way the decision was made. If it finds that the way the decision was made was unlawful, unreasonable, or unfair, it can order the local authority to remake the decision. If needed, it can also order the local authority to take a specific action too. Judicial review is possible where all other efforts to resolve the situation have been used and there isn't another way of considering a way forward. The time limit for applying for judicial review is as soon as possible, but within 3 months from the date when the act, decision, or event being complained about happened. So local authorities or other public bodies that can be taken for judicial review could be challenged on the following points: illegality, including acting outside their powers or by making an error in law; irrationality, in cases in which the decision is completely unreasonable; procedural unfairness, including carry out procedure unlawfully breaching the rules of natural justice, failing to consider legitimate factors or considering illegitimate factors; or a breach of the Human Rights Act. So some actions to take when considering judicial review. In order to go forward with a judicial review, it would be recommended to gain some legal advice. It may be helpful to check if you're entitled to legal aid, and you can find a legal aid checker here on this link. The first part of judicial review is called a pre-action stage. This is where a formal pre-action letter is sent to the local authority outlining the issues and providing them with an opportunity to resolve the matter. Again, taking legal advice for this purpose is recommended to ensure a pre-action letter contains all the relevant points. If further action is needed, parents, with the help of their legal representative, must then apply for permission to bring a judicial review to the Administrative Court of the King's Bench Division of the High Court. Parents, with the help of their legal representative, could ask the court to take action or stop an action before the case is heard. However, this would be temporary until the court's final decision. It could take between 6 months and a year for a case to be heard. So what are the possible outcomes of a judicial review? There's a quashing order, where the court overturns a decision and requires the local authority to make it again. A prohibiting order, where the court tells the local authority not to perform an action or make an unlawful decision. A mandatory order, where the local authority is required to perform an action, for example, to ensure the help in an EHC is carried out. An injunction, where the court tells the local authority to do or not do something. A declaration, where the court says that a decision or an act has been unlawful. And damages. This is an order very rarely made in judicial review, but compensation may be awarded where a decision has caused harm or loss. This happens most often where there's been an interference with human rights. So now we'll look at the health provision in an EHC plan and how to potentially enforce that. For healthcare provision to be included in an EHC plan, in Section G, it must be agreed by the responsible commissioning body, which is usually the Integrated Care Board. Once healthcare provision is included in Section G of the EHC plan, it is the responsibility of the commissioning health body to ensure this is in place, and this legal duty is outlined in Section 42 of the Children and Families Act. For complaints about health provision, the complaint is to be directed towards the responsible commissioning health body rather than the local authority. So it's important to find out who that is so that you know where to direct a formal complaint. Again, if this complaints process is unsuccessful, then judicial review would become a possible option. And finally, to take a look at social care provision in the EHC plan. In the case of those under 18, social care provision, which is being provided under the Chronically Sick and Disabled Persons Act, will be set out in section H1 of the EHC plan and must be provided by the local authority. Any other social care services, including services under section 17 of the Children's Act 1989, must be included in section H2 of the EHC plan. If your child is over 18, the social care part of the plan may be provided by adult services under the Care Act, which will again be in section H2. The local authority may also include in section H2 any other social care provision reasonably required by the child or young person which is not linked to their learning difficulties or disabilities. So, if the social care provision is not being provided, you will need to complain to the social care department of the local authority. So again, see the previous information about Rotherham's complaints process. If complaining to the local authority is not appropriate, or if the complaint doesn't resolve the matter, then again you might need to consider judicial review. We hope you found this information helpful.